You know the routine now. The 1-minute self-introduction.
I would like to thank each of you for the opportunity that you have given me to serve as your Humboldt County District Attorney for the last 3.5 years. I am proud to report that the District Attorney's Office in the first 3 years of my administration has done more jury trials than the previous administration has done in 8 years. I brought a balanced approach to the office, though. Not everything goes to trial, but the serious cases that need to go to trial, go to trial. Those cases where it's appropriate, our office offers to the defendant a guilty plea agreement holding the perpetrator responsible for their actions and saving the county money. This balanced approach has paid off because in the 3.5 years that I've been in office, each year the crime rate has gone down. I look forward to continuing to serve you as your district attorney, and I ask for your vote in this coming election.
Hello, I'm Kevin Pasquale from Paradise, and I too am running for district attorney. I am absolutely tickled pink to see so many interested voters showing up tonight. I think that lack of interest speaks well for our community. In 1 minute, we certainly don't have enough time to cover everything that I think is a critical issue that needs to be addressed, particularly an issue that I became aware of yesterday about some gossip over at the courthouse. But to address these issues, please look at my webpage, kevinpasquale.com. I want to talk about not only that issue, but the rest of the issues that I think are important and need to be discussed and that we may not get a question for tonight. Thank you very much.
Good evening. I'm Michael McDonald, and I too am running for district attorney. I'm a lifelong resident of Humboldt County, and I've been an attorney practicing here in Humboldt County for the last 14 years. Prior to that, I worked as an accountant for 3 years in Humboldt County as well. Over those 17 years, I've worked successfully with government officials, business leaders, community leaders, and fellow citizens. And that's what I'll bring to the DA's office. In addition, of the 14 years in the legal profession, I worked more than 5 as a deputy DA in the Humboldt County DA's office. And I believe I have a strong cross-section of experience in all areas or duties of the office. There's room for improvement, and I'd like to offer that improvement if you vote for me. Thank you.
And the question is written, what factors should be used to determine if charges are to be dropped or plea bargained?
Thank you. You know, as Russell kind of mentioned, plea bargaining is a part of our system, something that we've become accustomed to. And there are certain plea bargains that nobody seems to mind. Russell uses the example often of dropping the speeding ticket that came along with the DUI in exchange for the plea to the DUI, and I don't think anybody has any problem with that. I think where we see problems in the plea bargaining process is when it's the more victim impact type of crime. And in those crimes, attention has to be paid not just to the victim, but to what's going to happen in the community as a result of that plea bargain. What message are we sending to them? Potential offenders, to potential jurors, and when it finally boils down to plea bargaining and what is a good plea bargain, you have to start with being a good trial attorney. If you're not a good trial attorney, if you can't persuade your defendant to know that you are a good trial attorney capable of taking him to court at any time and beating him, you have no leverage in that plea bargain. And so every defendant needs to know that there are sufficient resources to try his case, and that his case will be tried vigorously, and that he will lose. And that's what makes for successful plea bargaining. And on the more significant issues. Thank you.
To be a good prosecutor, you have to be prepared. Not only does that include legal research, but more importantly, it is understanding the facts of the case, talking to law enforcement, witnesses, or other folks involved with the case. The facts determine how we proceed more times than not. The legal profession is the application of facts to law. In determining what your offer may be in plea negotiations, you have to determine what are my strengths in this case, what are my weaknesses, what is this case worth? And sometimes it's very difficult. The toughest thing to do as a DA is look at a family and say, you know, I know little Susie or little Johnny was victimized, but the facts do not support us moving forward with that charge to a jury trial. We can proceed with something less. Those conversations are brutal. And I believe that all three of us agree that that is a tough situation for the prosecutor. But preparation prior to hitting the courtroom is the key. Thank you.
Couldn't agree more with everything that was said, and I think our district attorney's office does a very good job in offering guilty plea agreements. In the state of Nevada, we have a thing called a guilty plea agreement, and it is synonymous, it's the same as a plea bargain, but it's outlined in the NRS of how we have to do that. It's a contract between the state and the defendant. Now, there are some reasons why you might charge a case and you might start forward, and then next thing you know, you're doing a plea offer that you didn't expect to do because evidence changes, new information is learned, and as was already pointed out, you can only go with what the case is worth, what facts you actually have. When a law enforcement officer brings a case to my office, all they have to bring it under is the lowest standard, which is probable cause. Now, I take probable cause, and I have to look at that and determine, can I prove this probable cause on each element of the crime beyond a reasonable doubt? And if one of those elements isn't there, you're not going to be able to move forward. And so that is why we go and we take the facts that are there, we apply them to the law that is there, and we make adjustments along the way as things come up. Why would one not go forward? Only for two reasons that I can think of. The facts have changed and evidence has slipped away, or you have a situation where, while all the facts are there, your victims no longer want to continue to pursue. And if they're not willing to pursue and they're not willing to testify, you can't prove beyond a reasonable doubt. Those are the reasons that plea agreements are out there. Those are the reasons sometimes when we charge somebody high, it ends up when we're all done at the end of the day, it's lower. I wish that everything we charge could be held to that, but unfortunately between charging day and a year later when you go to trial, facts change. Thank you.